family quiz number 3. So in a fact-finding hearing, the evidence that can be submitted is always going to be competent material relevant. Okay, number 3. If the court decides to suspend judgment in a neglect, the maximum period of the suspended judgment shall be 1 year, and the fucking extension is only 1 year. That's it. You get 1 year, and then you can get up to 1 year extension. Now, that is true whether we're talking about a neglect in Article 10 or in Article 6, which is termination of parental rights. The question here labels it as 633, and then it says neglect, but actually it doesn't even matter what it says, because both neglect and Article 6, so Article 10 and Article 6, it's both 1 year. Number 4, 717, proper venue for appends is the county where the acts or acts referred to in the petition occurred. So A, one only. 737, this is number 5. A summons in appends proceeding must be served by delivery of a true copy thereof to the person summoned at least 24 hours before the time stated therein for appearance, if so requested by one acting on behalf of the respondent or by a parent. The court shall not proceed with the hearing or proceeding earlier than 3 days after such service. 664. I knew this question would show up somewhere. So it wasn't in the civil section that we had to do, but hopefully everybody remembered it. The court may not conduct an in-camera interview of an infant to a custody proceeding unless a stenographic record is made. 7. The family court has original and concurrent jurisdiction with the surrogate's court over adoption proceedings. Again, the family court has original concurrent jurisdiction with the surrogate's court over adoption proceedings. Number 8, 617. Service of a summons and petition under this part shall be made by delivery of a copy thereof, a true copy thereof, to the person summoned at least 20 days before the time stated therein for appearance. So again, this one is 20 days. Articles 4 and 5 are 8 days, and then I think pretty much like 7, 10, and 3 are all 24 hours. The family court has like jurisdiction and authority as is now conferred on county and surrogate's court as concerning the guardianship of a minor. 10, 617. In a neglect proceeding, service of the petition of the summons shall be ceded. Now again, this is a problem question because it says neglect, but it's not supposed to be neglect. It's supposed to be termination of parental rights. And it does make a difference in this question. So this question is totally fucked up. But obviously you should have figured out that since 24 hours wasn't an option, to go with D, 20 days. 745, number 11, at a dispositional hearing in a PINS proceeding, only evidence that is material and relevant may be admitted. Members of the same family or household. So members of the same household include, and this is question number 12, and the answer is A, so let me just read them. It's persons related by consanguinity or affinity, so that means by blood or marriage. 2, persons legally married. 3, persons formally married. 4, persons who have a child in common. That definition does get more complicated, but I think I have it in another video. Venue in a family offense proceeding is properly located in the following places. So now, even though this is seems like sometimes it's a quasi-criminal thing, it's really civil in nature, and that's, you'll see in number 13 when you answer this question, it's the venue is where the county where the acts occurred, county in which the, quote, household is located, or 3, county in which the petitioner and or respondent resides. So it could be any of those 3, and that's why it's more civil in nature. In a family court, a family offense proceeding, which any of the following are entitled to free representation if indigent? And the answer is C, both petitioner and respondent. 821, when a respondent is produced before the family court on a family offense proceeding, which, if any, may be done by the family court judge. So, number 15, the answer is A, which is all of them. Release the respondent on his own recognizance, direct the respondent to post bail, or issue a commitment order directing the respondent be remanded until bail is posted. 723. After taking into custody a person alleged to be subject to FCA Article 7, a private person must take the person without... Oh, yeah. So this question is also screwed up. This is number 16. And the question is screwed up because the answer C that's listed on the answer key says without necessary delay. And that's obviously wrong. So, yeah, if you got that one wrong, don't worry about it. 17. 744, true or false? True. Because it's a fact-finding hearing and it's a repeat question. Competent material relevant. Fact-finding Article 7, proof beyond a reasonable doubt. It has to be proof beyond a reasonable doubt. That's quantum of proof. Only evidence that is material and relevant may be admitted at a dispositional hearing, so that is false. Number 19 is false because it doesn't have to be competent, which usually means hearsay is okay. 20, 745, an adjudication at the conclusion of a dispositional hearing must be based on preponderance, and that is true. 21, a fact-finding hearing shall commence not more than blank days after the filing of a petition under Article 7 of the FCA if the defendant, they mean respondent, is in detention. Number 21, the answer here is listed as B. So 3 days. Yeah, it's 3 days. A fact-finding hearing shall commence not more than 3 days after the filing of a petition under Article 7 if the respondent is in detention. So basically, in Article 3, if you're not sure, guess 3 days. Who may originate a family offense proceeding? So number 22, this is coming right out of 822. And it's any member of the named respondent's household, a duly authorized association, or a person on the court's own motion. So the answer is D, 1, 2, and 4, but there is a much bigger list to that.